We cannot hear you, Deputy Chief Justice, if you are speaking. Thank you.
Yes, thank you, Professor Singh and Professor Williams. Most welcome to our class this evening, and fellow students. I think we are anxious now to begin, and I would simply say, can we start, Professor?
Excellent. Thank you, Deputy Chief Justice. Thank you, Professor Hauha. All respectable judges, delegates, I'm very pleased to start our next class session. Today is a special session where we are getting into a more specialization, if I should say, specialization within mediation in this advanced mediation course. You've already met Judge Alex Williams, who is a terrific human being besides a great teacher. I will not reintroduce him as you met him already, but he has worked pretty hard to create a lecture today, which we will again conduct in a Q&A format on the art of mediator's proposal. Let me lay the ground for you and then ask Judge Williams the first question. The groundwork I have for you, in fact, I was mediating yesterday, and at some point it came to my question, can I make a mediator's proposal? And I told the clients, no, it is too early. I think you both have to work harder to come closer to the agreement stage. And then if we get stuck, I may. This idea of what is a mediator's proposal. Should a mediator make a proposal? When should we consider making it? And when we do consider making it, what is a proposal? How should you write or discuss it with the clients, with the lawyers involved? Let me make it provocative. Can it challenge your impartiality? Can a mediator proposal make you impartial? Does it make you uncomfortable? So these are some of the questions we might be looking into besides the timing, the methodology, the meaning of mediator's proposal. Let me invite Judge Williams to give his opening remarks today and welcome our class. Judge Williams.
Good morning. Dr. Singh, I actually want to note something that came across my desk just yesterday. This is the Bench magazine, which is the magazine for the California Judges Association. And they have an interview, they feature an interview of Judge Gladys Kamasanyu, if I'm pronouncing her name right, who's Uganda's chief magistrate in the wildlife court. And it was a very, obviously it's a bit far from what we're talking about today, but I thought it was remarkable that this article came across my desk and I read it last night. It's a very flattering article about her, what she and a couple of her colleagues who are magistrates in the wildlife court are doing with some of the challenges to wildlife and nature in Uganda. At any rate, good morning, Mr. Chief Justice, Deputy Chief Justice, Dr. Singh. And it is a pleasure to be with you, to continue to be with you. And as I travel around the world on my computer, and I have enjoyed our conversations over the past couple of days, this is an interesting topic for me because not just because of the mechanics of a mediator's proposal, but as Dr. Singh pointed out quite correctly, the question becomes, are you doing the right thing for a lot of reasons, not only to settle the case? Are you casting yourself more as an arbitrator than a mediator, the more specific and more directory and more the stronger you come and move in that direction? Generally speaking, I think for most mediators, including myself, that the mediation session and the mediation process is a journey, and we start off in a very supportive, conciliatory fashion, and only move towards more and more or a higher degree of specific recommendations and interventions as the mediation progresses and as the need may arise. And I see the mediator's proposal as sort of the ultimate in the drift, or not the drift, but the journey of the mediator from the process of building trust and a collaborative spirit, and the process, as Dr. Singh mentioned, that makes us remember that it is generally too early to do a mediator's proposal unless you've made that journey and gotten to the point where the parties expect you and in fact need you to put your thumb on the scale, perhaps to move the process along, being a little less facilitative, cash in those credibility chips that you have earned at the beginning of the process as you push it forward with a mediator's proposal. So I think that I see that journey that way, and I think that that's the theme that Dr. Singh is setting for us this morning, Doctor.
Yes, sir. I appreciate your comments. Wonderfully laid out as usual. I also see the Chief Justice, Honorable Chief Justice, has joined us. Chief Justice, if you're here, would you like to comment before I keep going? Thank you.
Thank you. Good evening, Professor Singh.
Good evening, sir.
Yeah, I think it's morning at your place there. Professor Singh and Judge Alexander, good morning. And good evening, class. Am I being heard?
Yes, to us,
Yes,
you've been
I hear
heard
you.
loud and clear.
Thank you. I just wanted to say something brief before I hand over to you, hand the class over to you, Professor Singh and Judge Alexander. We are really grateful for this hands-on session at the tail end of the MDR program. This interaction speaks to us in many ways, most importantly, transiting from role of a judge on the bench to that of a mediator, which really is our ultimate aim, those of us who are on the bench. To this end, there would have not been a better combination of two seasoned facilitators, one from the academia and practical experience, and the other having transitioned from the bench, like we intend to do. We look forward, as I said, to the very best out of this combination. On behalf of the class, we can never say thank you enough. Over to you, Professor Singh. Thank you.
What a beautiful opening. You want to make a quick remark, Judge Williams, before I?
Well, I am delighted. We always refer to our Chief Justice as the Chief or Chief, and I have served under a number of excellent Chief Justices in California, and I very much am honored that the Chief is, first of all, with us and attending this process. And he does flag the journey that they are on, and it is my honor and privilege to accompany the class on that journey to the extent that I can. It is a privilege and a rare honor and to serve as a judge in any forum, to be able to capture skills in that process and extend one's value to the justice system in a private capacity is also a special joy and a special privilege, and I am enjoying the company.
Wonderful. Thank you, Judge Williams. Folks, I want to start with a simple demonstration of where we are at. We are looking at this slide together, if you may, and this is the recap from our mediation. This is advanced mediation, our ultimate course, and we are assuming you remember this, but I want to give a quick feedback, if you may, recap, if you may, of this grid. Professor Riskin, in fact, was my professor at University of Missouri, Columbia. I remember him vividly, and he created this grid. He, in fact, came with a few of these grids. He called them new grid, new grid, and then new grid. And this is the new grid. If you look at this in the very bottom, the job of a mediator is to facilitate. And maybe at some point in the mediation, if the mediator may move towards evaluation at the very top. Some mediators have a choice to start facilitating broad, which means talking about anything on earth, to facilitating narrow, which means focusing only on legal issues or factual issues in the case. So this tension that many of us feel, well, let me say a couple of more things. Professor Riskin also said that this grid, if I'm not wrong, I'm trying to summarize many years of work of a professor in a few minutes. So my apologies if I make a mistake in this. My understanding is that he also suggested that a mediator can be anywhere on this grid and still be a good mediator. That also different mediators are at different places on this grid. For example, commercial mediators in Los Angeles may be on the upper left-hand corner of this grid, narrow and evaluative, whereas community mediators in Salem, Oregon might be on the right-hand side bottom of the grid, which is facilitative broad. So it's also the context. It's also the parties and the culture. Yesterday, I did a mediation between two clients who own businesses worth millions of dollars, but the clients came from India. So I could feel that throughout the mediation, I had to switch between evaluation and facilitation. Evaluation to gain their respect, facilitation to promote the dialogue. And having worked cross-culturally, I realized that was an important piece for me to keep them energized, to keep them entertained. And I did not give up on that because it is part of that attention we have to keep. Just like in teaching, in mediation, we must keep the attention of the people in the room with us. So Judge Williams started today discussing this idea of mediator's proposal. My first question to him is, Judge Williams, looking at this small grid, is mediator's proposal on the grid? If yes, where would you place it, sir?
Well, I think that it can be certainly analyzed in terms of the grid because the grid is comprehensive. The grid is really designed by Professor Riskin to cover the entire landscape of potential activity by a mediator. At least that's the way I see it. It is certainly toward the evaluative end. Whether it's narrow or broad depends upon the case. We like to joke in the United States that the answer to almost every legal question is, it depends. Certainly in mediation, that is also true. I do a lot of cases involving fairly complex business situations, and therefore it might not be as narrow as it might be if the question was simply, what's the value or what's the settlement amount of money required for a personal injury case or for a breach of fiduciary duty or other such thing. So I think that the answer to your question, of course, I took a lot longer to answer it than perhaps it was required. I never met a microphone I didn't love at some occasion, but in all seriousness, it is plainly a broad, it is plainly evaluative toward the evaluative range, and it can be as broad as the facts require. One of the things I will talk about downstream among my a dozen comments we have here is you want to make sure that the proposal, as we used to say in the Navy, answers the mail, meets the requirements of the decision that needs to be made. And that when I do a mediator's proposal, I identify all the undecided, unagreed issues in the case and either get a decision on them, get agreement from them on them, or include them in the mediator's proposal. However, the more things you include in the mediator's proposal, you by that amount multiply the likelihood of it being turned down. You want to minimize the number of questions, a number of issues to be resolved by a mediator's proposal, but you do not want to leave issues unresolved in that process because then you get into this the silly season where somebody will say, we accept your mediator's proposal and I'm happy to pay you $1 million, but we want to do that over 15 years or 10 years or 5 years or something as such. So you have to resolve all those issues at that time.
Allow me to recap just briefly what Judge Williams is telling us. He's telling us the mediator's proposal can be both narrow because it has to narrow on the scope. You can't just make it so broad that it covers everything on earth. It'll be unenforceable. It'll be unagreeable. At the same time, it has to be broad enough to include parties, terms, interests, and perhaps their solutions. They're ideas of coming to an agreement. Am I right here, Judge? Is that what you were saying?
It is, and it is. You were right to think broadly about it, because basically you want it to end the process. The mediator's proposal should be the culmination of the process. Sometimes you can make a mediator's proposal and agree that it will simply advance the ball to the next stage. I have had occasions where I've actually dealt with perhaps 3 mediators' proposals over the period of a year when I was working on a case that took that long to resolve. But yes, you have encapsulated. You want to answer the issues, but you want to do so by as much as you can by agreement, as opposed to by mediator's proposal. In other words, you want the process to go as far as it can go, to the point where everybody feels like we are at impasse, and then that's when the most valuable mediator's proposal is the one that answers the required answer and makes it as simple as possible, as opposed to leaving too many issues or any issues loose. You have to close the case on that proposal if you can.
Thank you, Judge. As usual, very helpful. Honorable Judge has prepared small remarks for us. Judge, can I put up the definition of the mediator's proposal? Would that be okay with you?
Yeah, absolutely. Anything you'd like to do, Dr. Singh.
Thank you. I would like to pull this up again. This is work by Judge Williams, not by me, and I want to pull this up for you all to watch. When Judge Williams, again, goes to the character and integrity of a fine legal mind, is to put effort, and he prepared this for us. So
I have no idea who you're talking about, but thank you.
You ask your wife, and she'll help you. So so here we go. So the definition of a mediator's proposal is a proposal from the mediator concerning the terms of settlement. Each party separately accepts or rejects the proposal. If all sides accept, we have a deal. Let me ask you a question on this, Judge, if that's okay with you.
Of course.
When you say each party separately accepts or rejects the proposal, are you saying you give the mediator's proposal separately to parties or at the same time? And then, yes, please.
I give that to them at the same time, but I want it back from them separately. In other words, I want everybody to receive the mediator's proposal at the same time. I don't want to give somebody an advanced view or a delayed view of what I'm proposing, because my proposal might be 2 or 3 pages long in terms of both details and justifications. One of the questions down at toward the end of my conversation is in paragraph 9 of my notes for today. The question becomes, how much do I tell them why? I may tell them what, and then I've got to decide, do I need to sell it, or is it does it speak for itself? So I send it out to everybody at the same time by email to counsel only. But I do it in writing, obviously in email, because I want everybody to see it, and the people that may need to see it may not be in the room when the proposal is made. So I rarely do a mediator's proposal that is oral or is intended to be decided on site, because, among other things, sitting here in California, we have to deal with the reality that almost all of the major insurance companies tend to be located in the eastern side of the United States, and I want them to get the proposal so that everybody is persuaded that I've knocked on every door with this mediator's proposal. That's why I do it by email, and we agree as to how much time we should allow for response. A couple of days, sometimes a couple of weeks, depending upon how many folks need to look at it.
Judge, I'm going to ask you something very different, just for the sake of taking a break from a very dense and scholarly topic, if you may.
And I welcome that.
I'm an emotional guy. I work through emotions. I work through passion. Everything I do in life is through emotions. I believe life is about emotions. I believe we are a bundle of emotions, and we fool ourselves that we are a bundle of rationality. I believe we act, we react, we decide based on emotions. I believe we are moved by emotions, and we are promoted and we are thought out through emotions. So I think the biggest movements on earth are emotional. I think the biggest change we make are emotional. How much emotions do you put in your mediator's proposal? Two-part question. One, is there an emotional investment by you, so much so that if the parties do not accept the mediator's proposal, do you get shaken up? Do you get rejected? Do you feel you have failed as a mediator?
All of the above. I long ago learned that although as a judge you want to be dispassionate, you want to be fair in every definition of that term, fair in process, fair in result. It is undeniable, certainly at least when we get into mediation and the depth at which you develop and work on the case, which is far in excess of what a judge usually spends on a case in the courtroom. You go into great depth. I have found that I think, naturally invested emotionally in the result. And if they turn me down, or if any one person says, no, we do not have a deal, you need to get everybody on board. And that is an emotional thing. I have learned, I hope, to check my emotional guns at the door, as we used to say in the American West, check your guns at the door. I know that part of the reason I came into mediation was at the encouragement of a colleague, was that I was finding my work on the bench to be quite stressful. I would have situations where I have 6 cases ready for trial, 30 or 40 potential jurors in the hallway waiting to come into the room. The only thing they can see is my name on the door that has not been opened for them yet. And remember, judges are elected here in California. People can vote for and against you. So it is undeniably emotional, but I believe part of the duty of a judge is to temper those emotions with empathy. And sometimes self-care is involved in that too. I need to make sure that I don't set myself up for failure by making a proposal that is premature or not comprehensive enough, or perhaps, as you noted earlier, potentially perhaps too comprehensive. It is a delicate balance, but and I would add to that, a lot of my cases are business cases, and sometimes people like to think that business cases somehow don't have emotions in them. I respectfully say that's nonsense. A business case usually involves a company that somebody has spent their lifetime developing, or a company that somebody has spent a lifetime working for. And it is a very emotional matter. But I need to make sure that my emotions are in check. The most important control in mediation, I believe, is self-control. And that's been part of my journey.
I appreciate that, Judge. I thank you for that answer. As I make you think further down this position of mediator's proposal, my question then comes about timing.
Yeah, good question.
I want to know, you mentioned just now, you used the word that you're thinking that a proposal cannot be premature. And I'm taking that as a question of when a proposal needs to be ripe, when a proposal needs to be, when we have to be careful when the proposal is that right. So I don't have anything. I just want to, let's just focus on this one word, timing. Tell us about, walk us through, like we don't know anything about this proposal. Walk us through, how do you decide when it is the right time? What is Judge Williams thinking about, okay, I think now is a good time to make a proposal?
The first thing I do is to wait as long as I can, because I would prefer that the mediator's proposal be counsel's idea as opposed to mine. I want it to be an execution of a vision that they separately have, as opposed to an imposition of my vision on them. And that often happens, because if a person says, Judge, do you do mediator's proposals? Or Judge, what do you think about a mediator's proposal here? what is that party telling me? That party is probably telling me that they will go farther on a mediator's proposal than they would go in a normal, continuous distributed bargaining auction type scenario. At least that's my choice. At least that's my interpretation. So I would rather see somebody propose it, even if I then shield that from the other side. In other words, party A, the plaintiff may say, Judge, we think maybe you should consider a mediator's proposal. They may not want me to tell the defense that they've suggested it to me, and I don't have to. I will never lie, but I certainly respect confidentiality. I don't tell falsehoods. But I will then perhaps treat it as my idea as opposed to the other side's idea, because I know you and I have talked a lot about reactive devaluation. How somebody will devalue an idea because it came from the other side. Hopefully, if it comes from the mediator, it has greater trust and less suspicion associated with it. So that's the first step, is I wait as long as I can and hope that somebody else will raise it. However, if we are stuck, we are stuck. And if I've tried all kinds of things, perhaps an effort to get some sort of range, a mediator's range, as opposed to a mediator's specific proposal, try to see, can we move in and bracket this case a little bit. The exchange of brackets, as you know, is where parties make proposed moves as opposed to actual moves, trying to see what the other side might be willing to do. But if when the day is done, if I do have to consider a mediator's proposal, and in fact, Dr. Singh, as you and I have talked about before, articles in the local legal newspaper here, the Daily Journal, have talked a lot about mediators' proposals, or have featured interviews with mediators who speak about mediators' proposals. I have heard estimates that as high as 75 to 80% of the cases that settle in mediation settle on a mediator's proposal. They are widely used, widely understood, widely and one of the problems is I need to know whether or not the people are there to settle the case or are there to pass the buck to me to try to settle it with a mediator's proposal. It's a risky enterprise. I used to joke, and I hope the Chief Justice will pardon me when I note that I joked that when I was on the bench, I learned that it was a lot better to be affirmably vague as opposed to reversibly specific. And the less the parties know about what I personally think about the case, it may be the better for me, better for in terms of the success I have as a mediator. So I look around to see how much can I learn, how much can I do? Do I think it has a fighting chance to succeed? Because if you make a mediator's proposal and it's not successful, the temptation is to sort of walk away and say, well, that's the end of that. Now, I will never do that. You never, ever quit. You keep on, you don't give up, you follow up, you try to do something else. And as I note in my notes here, hopefully the mediator's proposal has at least cracked the ice. And I've mentioned some numbers that nobody's been talking about so far. And hopefully that will re-energize the process and push it to conclusion. So a failure of a mediator's proposal can be a step toward resolution also.
Let me recap here what Judge Williams is telling us, folks. He's telling us that I wait as long as I can. So it can be counsel's idea, not mine. Very, very interesting point. When both sides are ready, so not just one side thinks, okay, that's a good idea. Both sides have to be ready. Mm-hmm. When I can frame it as my idea, so both parties think that I am also ready, not just they are ready or one side is proposing for it, because they don't want to work hard. They want the result to come from the mediator. At that point, I want the result to come from me. Reactive devaluation, the term Judge used, basically means we react and we devalue what our opponent in a negotiation offers to us because of the word I just used, opponent. It also means judge is telling us we should exhaust all other remedies like bracketing or hypothetical offers. He's telling us there's an art and science to it. Don't be too quick. Don't be too late. Timing is important. And lastly, it's not about personal thinking, but it's about the case. Judge, let me pick up on the very last sentence. And now let's get really, I think, very provocative. I think this is going to keep people up for next 5 nights. I don't think people are going to sleep after hearing. I think Chief Justice is going to write an essay on this and get published next year in Harvard or Pepperdine journals. So this is revolutionary stuff coming up, folks. Right now, it's coming up. So open your ears and minds and hearts and eyes, and here it is. You ready for this? Okay, here it is. Judge.
Yes, sir.
You are saying it's not about personal thinking. Well, I'm going to challenge you, and I'm saying it is about personal thinking. We are getting paid. We are getting hired to make a personal opinion. Why do you say proposal is about them? Isn't proposal about what you as a mediator think about them and their case? How can you be objective? And I'm not saying you're wrong, Judge. I'm just making this life-changing event for people. That's why I'm being provocative. I'm just saying, how can you say this is only about the case and not about the people? It's not about you. Isn't all of this intrinsically connected?
The answer is, of course. However, and
I hope you had stopped at, of course. Where did however come from? It's all right. Go ahead.
Listen, first of all, I'm impressed that you managed to put this together as we were working. My case manager has the same skill, and I envy you. But the answer is, of course, my sense of what I think is material. However, in the landscape of the lawsuit, I am really operating in a range that has been defined by the parties, whether they know it or not. And yes, my thoughts are, if I think that the legal theory on one side or the other is weak, I will share that view, perhaps, or not. I would do so usually by questioning, what makes you think that works? Help me understand how that works. I prefer, again, as much as possible, to tailor the mediator's proposal to the landscape that has been defined by the parties. But yes, particularly if I have a strong view about what the state of the law is, and probably would have shared it, I would probably fold that into the process because I want it to be successful. It's interesting, however, Simran, Dr. Singh, about it, as we talk about this, there are a lot of consequences to a mediator's proposal that a judge needs to think about, a mediator needs to think about. When I initially started in this business, I really regarded a mediator's proposal as essentially a suicide move, that the mediator was putting her or his fingerprints on the deal by making a mediator's proposal, and that therefore impartiality was out the window, that was it. I came to feel that was a mistake, and that in fact I should do everything I can, both at the time of the proposal and even thereafter, to keep the process moving. And as I may have mentioned it earlier, that even a failed mediator's proposal itself is a step toward resolution for one side or another. But in the end, I don't want anybody to say, we settled because the mediator advised me to do so. I'm not there to give advice. In fact, I cannot legally give legal advice in my capacity as a mediator. It's complicated because in California, the state bar regards me as practicing law, even though all I do is mediation or an arbitration. I don't do any legal advice at all. But the state bar still wants my money and gets it through that way. But I'm not giving, and I tell my students this, if in fact somebody says, I settled the case because the mediator told me to or advised me to, that's not mediation. That becomes arbitration. And I think that it's very important that to the extent my views are there, either they have been stated or they are consistent with the conversations that I have been involved in with the parties. But in the end, the best mediator's proposal is one that matches, that arises naturally from the positions of the parties and not just purely from the mediator.
Excellent, from the position of the parties. Two questions again, as you can imagine, have more questions, but let's just go to this idea.
That's a good thing.
Yes, let's just go to this idea that you are presenting here, Judge, which is, 1 second. The idea that we have to listen to parties' positions, right?
Of course.
Fine. We have to listen to parties' positions. But here is my challenge with that. You're using the word range of bargaining. You are saying parties have a different range for the bargaining. And I agree with that. Parties is defined by the parties. On one side, I need 10 million. On the other side, I'm giving 100,000. That's range. What if that range is purposefully, and as you know, many times it is, controlled by posturing? That is not reality, but is perception. And which happens in every negotiation, exaggeration, anchoring, puffering. We hear that as lawyers. We know what that is, and judges. But what if, not that it happens ever, but what if parties are manipulating us towards a proposal by giving us a wrong range?
That's a very fair question, and it's one that obviously as a mediator you have to consider. And do I know enough about where the parties are that I can frame this result, this proposed result in this case, in a fashion that makes them comfortable? And there's an interesting byproduct to this also. Practically speaking, if a mediator's proposal does in fact involve an intervention by the mediator in the process, and it's become more and more popular. As I mentioned, a very significant fraction of cases that are settled now are settled with mediators' proposals. It's an essential toolkit, a tool in your toolkit. I still maintain that there's room in that process for me to know better, and one of the things that mediators do that I have started doing in mediators' proposals is actually to vet the proposal, not so much to get prior approval, although it comes close to it, but I've had conversations that will say, would you give serious consideration to a proposal in a certain range, and see how they play it. I had a case within the last couple of years where the plaintiff was adamant that they needed X amount and would not settle without it. I thought they were posturing, and I never let anybody define the range. I let them tell me what they want to tell me, and I listen. And so I built in an adjustment that was consistent with mediators' proposals generally. However, the plaintiff's attorney, as he had already told me he would do, turned it down, and the case did not settle at that juncture. It settled later. But one has to get a sense of when they are and when they are not spinning you. And in this particular case, as I looked back on the journey that almost aborted on this case, I did realize that this plaintiff's lawyer had been consistent all through the process with that number. There were other terms of the business deal that were where he was much more flexible on. He had been consistent. He had reasons for it. The reasons were not frivolous. They were fact-based and finances-based. And I think that I made a mistake in that case. Now, the good news, I was able to pull it out of the ditch, as it were, by adjusting and saying, okay, we didn't like that one, let's try something else. And they want you to persevere. And one of the things, as you know, our legal newspaper that I mentioned earlier, I refer to it as the world's most expensive newspaper. It costs a fortune to get it delivered at home. They feature a mediator every week, or a neutral, usually a mediator, every week. And those conversations have reflected that mediators' proposals are a big part of the practice, and I have actually aware of circumstances where you might succeed in the proposal and getting the case settled, but the lawyer may be very unhappy with the choice you made, and that may lead her or him to not engage you the next time they're looking for a mediator. So you may win it in terms of the case, which is what you're supposed to do, but the disappointment in the position you took, and that you therefore theoretically cause somebody to have to agree to, may impact your future business. It's a funny thing about how that works out. But in the end, I love what I do what I love, and so be it.
I
That
want to
includes working for you, by the way, you know.
I'm gonna move towards conclusion maybe over the next few minutes, so we can give a chance to our honorable guests to have an interaction with us on this topic. But
Okay. Are we working for 2 hours or 1 hour today?
we are going to conclude the topic in 1 hour and
see.
see how far people won't have time. It is a little late in Uganda because we have 1 hour time change, but we'll see how long we
see.
can go.
Well,
Anyways,
whatever-
they're not going to sleep with our discussion. We have such a provocative discussion. Nobody's sleeping anyway. So
Thank you very much.
okay.
Yes, sir. Next question.
Next question I have is, when you think of a mediator's proposal, what do you think of the methodology? How do you create it? How do you have a sample proposal? How long is it? You said you don't give it oral, verbally. That means you give it in writing.
Yes.
And speak to us about that. Yes.
I always do it in writing because I want it to get to everybody, not just the people who were there. And that's very important because typically, rarely, except in the biggest cases, you will not have an insurance person show up personally who has genuine authority. They may send somebody to occupy the chair, but the real power is in Hartford or Chicago or Madison or someplace in the Midwest or Upper East parts of the United States. And so I am mindful of that, and that's why I want it in writing by email so it goes to everybody. I don't have to worry that somebody mistranslates what I said, and that is important. But it does take time. Yes, I have a library of prior mediators' proposals, and they're usually a couple of pages long, usually about 7 or 8 operating paragraphs. The centerpiece is the 1 or 2 paragraphs that talk about the actual what I'm proposing. Other language there is about the mechanics of responding to me, not to each other, but to me, and then I will advise whether or not we have a deal, depending upon whether or not we have unanimity or not by the players in their response by email. I do use, I build on them, and I have a number of those that I've flagged as sort of good models for use generally as a mediator's proposal. But I have a copy of every mediator's proposal I've ever made, and it ranges into the hundreds as you would expect. Wow. Probably a lot more. So yes, that's what I do. I call up. I have a template. I flesh it out. I think about it. Usually then wait till the next morning to transmit, just to make sure, particularly if I know I'm doing something that somebody's not going to be happy with. Sometimes they know better, and they know you got to do what you got to do. Sometimes they don't, and but you are taking a risk as a mediator in doing so. But it is simply a requirement of the practice now to be able to do that. It is a big part of what you do.
Thank you. I think this is very. Yeah,
you did ask me. I'm sorry. I want to make sure you were responding to me about it. In formulating the proposal, if I might add just a second, and forgive me, Dr. Singh, speaking over you. May I speak?
No, it's fine, please.
Okay. Yeah. I note down in paragraph 9, formulating the proposal, what are the stated positions? What positions have they taken? And I keep a chart that keeps a very accurate record of who has proposed what and at what time. And I have I can certainly make that available. And it so that I know exactly where they are, at least in terms of their formal positions. I then look to what is it they've said to me privately that they haven't said to the other side. I look at, I will now invite counsel. I've said, what do you think the mediator's proposal should be? And in fact, what I do now formally offer to counsel, and then I adjust as they see fit. If we agree that it's going to be a mediator's proposal, let's say that we're in session on Tuesday, and I tell them that I'll send out a proposal by Friday because I want them to think truthfully that I spent a lot of time on it, and I do. I will also tell them that on Wednesday, I would love to receive from them, if they choose to, an email about what they think the proposal should be and why. So I'm giving them an additional chance to give voice to their opinions. It's a fee-generating event. If I want to be cynical, it certainly may be of value to counsel, but it is particularly value to me. So, and that's a confidential document. So I'm trying to get as much information about what they want, because in the end, I could be as right as rain about what the case should be, but if I don't make a proposal that they can all agree to, I've not done my job.
Judge, I think it's a good time to open up for discussions. We have 10 minutes or so left for.
Okay.
I think you covered everything that I want you to cover in Mediator's proposal. I will just say that it's an art form. It is an art that requires intuition and feeling of that comes feeling of gut that comes from experience, that as to, okay, this is the right time to make the proposal, and science, which is how to make it, how to talk about it, how to present it, what to include in it, how to follow up to it. A follow-up is a big piece.
Yes.
And not shy away from it, and not see that as a failure, A, when you make it, and B, when it's not accepted. So I think it's a combination of all the above, besides the timing piece you so eloquently discussed.
Well, I certainly appreciate your summary, and I very much enjoy working with you on that basis. I think it's a good conversation. And
Thank you, sir.
Delighted to answer any questions or participate with you in answering any questions.
Thank you, Judge. My apologies to overspeaking. Folks, we are opening up now for discussion. Any questions on Mediator's proposal as well? Welcome. So one question I see in the chat is, does this fit in with evaluative mediation model? I personally think it fits very well with the evaluative mediation model, but I want to let you answer that, Judge.
I do think it really is the ultimate in the evaluation model. You are actually making a specific proposal. That's as far as you can take it. So, and I would say that I don't operate, I hope I made it clear that I think in my mediations, I know I start off not evaluative at all. They're looking for it. They know I'm a judge. They know that I have a certain strength of opinion, to say the least, or they wouldn't be there. That's people choose to come to a judge because they expect that judge has the ability as a mediator to be evaluative, and there's no question that judges are seen as more evaluative than perhaps those who have not been on the bench. But I don't start there. I start as facilitative as I can, and then carry it along. And yes, it then becomes what I would call the ultimate in the evaluative mode is the mediator's proposal.
Excellent. Thank you, Judge. Other questions, please? I see there's Francis Gamara, please.
Thank you, Professor and Judge, for a very insightful discussion on proposals. I hope that the notes that you use will be shared. That would be very, very good to have them. But in addition to that, I wanted you to elaborate on a situation where the lawyers are not in the room. Have you ever been in a situation where you carry the mediation with the parties? In such a situation, how do you elicit their comment on the proposal? Because earlier on, you discussed about sending the proposal back to the lawyers so that you can elicit contribution to the proposals. But in what have you been in a situation where you do that to the parties? And if so, what is the best way of getting the parties involved in shaping the proposal?
Thank you for your question, Judge. I want to make it clear, I never meet with the client without the lawyer, except unless in the most unusual of circumstances. I really have to respect, first of all, the attorney-client relationship. I simply do respect it. Secondly, that though they're the ones who brought me the case, so I'm certainly going to involve them. So the mechanics of the mediation are that I'm going back and forth between the two rooms. Sometimes I will have a meeting of the lawyers on both sides, but only if they are agreeable to it. But I generally, 99% of the time, will be dealing with the lawyer and the client in one room, and then go over to the other lawyer and the other client in the other room. So there's not a separate disclosure to the client. I expect the lawyer, in fact, the lawyer has an ethical obligation to let the client know of any proposed settlement, including a mediator's proposal, and they will confer. And then the lawyer, I send it out to the lawyers by email, and the lawyers will respond to me separately by email. Let me know if that's the scenario you're talking about, or do I need to, is there something else I can give you in the way of an answer?
Yeah, because there are some times when the lawyers can say, okay, I think in this mediation, talk directly to the clients. We are happy for you to proceed and discuss with the parties and try to help them get a settlement. I'm looking at scenarios like that.
Okay. And I apologize, Judge. I want to make sure you understand that what I was saying is that I never do anything. It is really rare. Almost never would I meet with a client without the lawyer. I just think that is fraught with every kind of misunderstanding, and I simply don't do that. Well, who knows? I've had a couple of occasions where something very emotional has come up that the lawyer is happy to have the client let's speak to me, and sometimes they'll trust me with that, but it is simply not what I do.
Yeah. Understood. Thank you. Thank you
very much, Judge. I appreciate the question. I enjoy working with judges, so we should do this more often, Dr. Singh.
You're here by popular demand.
Well, I'm honored. I've really enjoyed this conversation.
No, I think the question might have led to an idea that in some cultures and countries, perhaps not every mediation is attended by an attorney.
I see.
Perhaps some mediations are controlled by clients.
Okay.
And what do we do when we don't have attorneys? Now, maybe the question can be, do clients have sophistication? Or are they sophisticated enough to understand the dynamics of a mediator's proposal? Perhaps let's take the discussion further. Perhaps it doesn't become a proposal, but it becomes more of an idea, a sharing in more of a layman terms as to what we are thinking. And they may be okay with that.
Well, first of all, thank you for pointing out and opening my eyes to the fact that I was thinking in a narrow framework, to the extent that every case I have has lawyers on both sides. And most mediators who are in the business I'm in simply do not have cases with pro pers, people who, that's the Latin word for appearing for yourself in propria persona. Most lawyers, in private practice, once I have had a case with a couple who were had some sort of a relatively minor dispute, and they were professional people and not lawyers. I simply made it clear to them that I cannot give legal advice, and I'm very rigorous about that. I think that's a dangerous path if a mediator lets himself or herself get into a position where it appears they're giving legal advice. And that's one of the dangers of having somebody appear who is improper, representing themselves with their counsel. But it's just not part of my normal practice, nor is it common in the practice at all of ADR Services, the company through whom I work.
Thank you, Judge. I see there's a very good question by Judge Paul in the chat. Let me read that. And I read that by sharing that in the chat. I've also added the one-page outline that Judge Williams had created for this class. That's for you all. And the question, Judge, is what happens when there's a conflict between an attorney and a client regarding a proposal?
Wow. Tread carefully. First of all, whenever I have a disagreement, and I'll enlarge the answer to cover any kind of situation where attorney and client are disagreeing. Normally, they don't let me know that. They will be, when I come in and meet with them, I like to say that there are two conversations that are material to my work. One is the conversation I engage in with the party and counsel in that separate session or caucus, if you want to call it that. And the other is the one I want to provoke when I leave, that I want to see take place or have take place when I'm not in the room. And often that's when counsel and client will discuss what they agree with or not. And sometimes they'll say so. Either the client or the lawyer will say, Judge, the client is concerned about this or that. And I certainly listen. I never get between them, the attorney and client, and I will never, if I disagree with a lawyer's position on anything, I'm rare to speak to it. But if so, then I would ask to speak to them separately without their client. That's a delicate matter. I don't like doing that because then the client's reaction is, what are they doing? Are they doing some secret sauce kind of thing there? And what's happening? So normally speaking, if there's an attorney-client conflict, I will try to help them work through it, perhaps. And my first comment will be, can I help? And what can I do? And maybe the attorney will guide me. But part of what I do is, I will be honest about it, is to support the lawyer if I ethically can, because A, I think that's the way the system is supposed to work, and B, that's the person that brought me the case. The lawyer is the one that chose the mediator, and I want to make sure that I honor that choice. I hope that responds, Judge Paul, and if not, feel free to push me on that.
Judge, I think from our side, my side rather, you have done an exhaustive job of explaining to us this art of making a mediator's proposal. To the class, I will be sending you a sample proposal, which is crafted by another judge here in the US, which is redacted, but with his permission. So you can feel free to read it carefully and use it as your deem fit. I do want to give a chance back to, there's one last question. Let me entertain that as well, and then let's close it. Mr. Toke says, is it possible that the proposal is a result of the outcome of the confidential listener? Can you explain that a little more to us, Mr. Francis? What do you mean by,
Thank you very much. I was just looking at, having read what Judge Williams was written as a timing for the mediator's proposal. I was thinking about the sequence that leads to the mediator's proposal. One of them I was thinking of was the confidential listener. After listening to what both sides have to offer, and then getting the ideas where each party is ready to go up to, then you can weigh the options and maybe give an offer in between. So I thought that could be, you could make that offer as after listening to both sides and as a confidential listener, maybe.
Well, Judge, thank you for the question. And yes, indeed, and I'll answer what I think I'm hearing you say, and forgive me if I don't capture it. Yes, I'm meeting separately with each side, and I am listening. I tell people God gave me 2 of these and 1 of these, and I'm supposed to use them in proportion. Listen more than I talk. And when I listen, people talk, and that's how I get a sense of where they are. So yes, indeed, my mediator's proposal may well be based upon confidential communications, which I don't disclose to the other side because it's confidential. So when I do a mediator's proposal, sometimes I explain why I'm making the proposal, but oftentimes I don't, because I don't want to get bogged down in the fight. When you start giving reasons for everything you do, then people start attacking those reasons. I just feel that it's better. But yes, indeed, my mediator's proposal is a result, almost always, of the outcome of confidential communications to me. I would be the confidential listener in that scenario, and that's where I get probably the bulk of my information that helps me to decide, can I strike a note here that both sides can respond to? Does that respond, Judge?
Yes, thank you very much. Thank you, Judge Williams. Thank you.
Thank you very much, Judge.
We have some more material to send you. And as you know, this class is a hybrid of both videos and live sessions. And we know it is late at your end because of time change. We want to be mindful of the attention span, but I also want to thank Judge Williams one more time with this phenomenal discussion. I have Judge Williams attended many discussions on this topic of mediator's proposal. I think what you did today was magic. In a very short span, you were able to cover.
I was well led, Dr. Singh.
I don't know. Thank you. I will like to give a chance for the Honorable Deputy Chief Justice or Professor Howard to close the session for us and wait for our follow-up video after this. But
thank you very much, both Professor Williams and Professor Singh. It's been lovely because we had done mediators' proposals previously, but I think we have come to a much higher level. And I think the skills have been delivered to us, the tactics, the patience. It's been greatly useful. Thank you very much and good night.
well, we'll have a good day, but good night to you all. Thank you all. Thank you, Judge Williams.
Thank you.
Everyone have a very wonderful evening. Thank you.
Good night.
And remember, you cannot sleep. You have to keep thinking about mediator's proposal. So,
Right.
Good night. Thank you, Judge. Thank you one more time.
Thank you, Dr. Singh.